Good morning, everyone, and welcome to this edition of MacroPro and Friends webinar series. I want to thank you all for joining me this holiday month. We just had Thanksgiving, and I hope all of you had a wonderful Thanksgiving and that Hanukkah started. So if you are a friend that celebrates Hanukkah, we certainly hope that you have a blessed 8 days. And of course, we have Christmas coming along the way, and I hope that everyone gets everything that they've ever dreamed of this holiday season, including being able to visit with family and friends again. So today we have a really great topic. Whose burden is it anyway? But before we get started, I wanted to just tell you a few things, a little bit of housekeeping, and then we'll get started with our fantastic webinar. So our webinar is worth 1 CEU. You will be receiving your certificate in 1 hour. It does sometimes take a while to get your certificate to download, so it does this little wheel thing. Just let it do this little wheel thing, and eventually the certificate will pop up. If it doesn't, and you're using Explorer, you may want to change your browser so that you can open it faster and easier. Next, if you have any questions for Jim, our speaker, you can put that in the question portion of the control console, and we will try to ask as many of those questions as possible. Any questions he doesn't answer, I will make sure that he gets a copy of it, and hopefully he will reach out to you with those answers. In addition to that, we have some really great handouts. So be sure to download those from the control console so that you have them. You can use them for the future. In addition to that, the law firm has provided additional information, and we'll have Logan on in a second, and she can tell us a little bit about what they have available to you. And then lastly, there is going to be an encore presentation on the MacroPro YouTube page. So I certainly hope that you will watch that. Now, for those of you who don't know MacroPro or don't know me, I'm Diane Cohen, and it is my pleasure to be your host today. MacroPro is a national document retrieval company, and we can get records for your litigated or claims file anywhere in the United States. In addition to that, we have gotten records on 6 continents, in 33 countries. So if you need records, we're not just in the United States. We can get records for you everywhere. Boy, that seemed like it was a little tongue twister for me today. So Logan, come join me.
Hi there, good morning.
How are you?
Hi, can you guys hear me?
We can.
Good, I'm good, there we go. I am doing well, thank you so much for having us.
You're welcome, and happy Hanukkah to you.
Thank you, happy Hanukkah. Yeah, so I just wanted to do wanted to introduce a few things, if that's okay with you, before I introduce Jim.
Yeah, so if you would talk a little bit about your company and maybe what handouts you have available, that'd be fantastic.
Absolutely. Hi guys, my name is Logan Schlossberg. I'm with the law offices of Schlossberg and Umholtz. We are a workers' compensation defense firm. We serve the entire state of California. We have 3 office locations, one in Los Angeles, which is where I'm at. We have one in Orange County, which is where Jim is at, our speaker today, and we also have an office up north in San Jose. So yeah, today we have handouts for you. We have the presentation attached PDF version, and we also have our wonderful workers' comp basics booklets. These are a fan favorite in the industry. They are attached, but if you'd like a hard copy, or for whatever reason you can't get access to this PDF, my email is going to be at the end of the presentation, so you can go ahead and shoot me an email and I can get you whatever you may need. So yeah, that's it from me, and I will go ahead and introduce Jim Umholtz for the presentation. Thank you, guys.
Good morning. Hopefully all of you can hear me. Hopefully I'll get the technology right. I am an old school guy, and technology doesn't always come easy to me. Let me hit a button here. Yeah, here we go. Let me start off by saying that my comments today are not intended as legal advice. Each case has its own facts and nuances that you need to pursue and consult with your own attorney. However, hopefully today I will give you some ideas, some advice, some strategy that will help you better defend those cases that you have. Now, one of the questions that I've asked myself time and time again is, why do we win cases and why do we lose cases? Now, back when I was in claims, I used to have attorneys tell me that we lost cases because of bad facts and we win cases because of great attorney work. I don't necessarily buy that. But what I figured out over time, and what I'd like to present to you today, is that understanding the use of the burden of proof can help us all do our job better, can help us decide when to fight and when to fold. So let me move forward here. My disclaimer. What is the burden of proof? Well, anybody who's watched a crime show, anybody who's watched a police show, know that's a standard by which a court makes a decision. And most of us know that for criminal cases, the standard is beyond a reasonable doubt. And that's a pretty high standard. We also know that for civil cases, the standard is preponderance of the evidence. In other words, basically, you have to have slightly more evidence proving one side than the other side. Well, the question comes up, what is the burden of proof in workers' compensation? Well, Labor Code Section 3202.5 says that we use the preponderance of evidence standard. The standard that says, oh, you just have to have slightly more on one side than the other. That being said, I should point out to you that Labor Code Section 3202.5 was created in 1993, and it wasn't until 2004 that the state of California said, oh, by the way, this applies to all dates of injury. Because prior to that, we had Labor Code Section 3202, which is the liberal construction clause. And when I explain that to people who don't work in the industry, I usually use sports analogies such as tie goes to the runner in baseball, or a soccer analogy where our goal is at the top of the hill and the applicant's goal is at the bottom of the hill. If they just kick the ball, it rolls in. We have a higher burden under Labor Code Section 3202, even though the Labor Code now specifically says that we're using the preponderance of the evidence standard. What else the burden of proof is it's a duty. In other words, an obligation on behalf of a party to present evidence to substantiate a claim. In other words, each party has to present some evidence to make their point, to convince the judge, to convince the trier of fact of the truth of the allegation they're using. Now, what I tell people is think of it as a tennis match. In tennis, someone has to serve to score a point. If there's no service, there's no point scored. Now, unfortunately, in our tennis match, the advantage is always with the applicant, but still, someone has to serve. So how is the duty, this burden assigned? Well, in most cases, it's assigned by law. When you read a statute, when you read any law, and there's the language must or shall, the party to which that must or shall applies has the burden of meeting that must or shall. But it's also assigned by custom and practice. And that means that the moving party, in other words, the party that wants something, has the initial burden of proof to prove each element of what they want. I'll say that again. The party who wants something has the burden to produce each element of what they want. In other words, in workers' compensation, an applicant cannot just sit there, do nothing, and prevail. They must present some evidence of their alleged injury. So we go, ask yourself, who wants something? Well, a finding of injury, the applicant wants that. So the applicant has the burden of proof for the finding of injury. For benefits, the applicant wants that. So the applicant has the burden of proof. Who wants to stop giving benefits? Who wants to prevail on affirmative defenses? Well, that's us. So in all affirmative defenses, the burden of proof falls on defendant. And for lien claims, they want payment, so they have the burden of proof. How is that burden of proof met? Well, because of Labor Code Section 3202, basically for the applicant, if they do make their prima facie case, in other words, show a basic showing that the facts they're saying are accurate, and those facts go unrebutted, they have made their case, and the burden shifts to the defendant to rebut what they said. I'll give you an example of that in a little bit. For specific injuries, essentially the applicant meets their burden by saying, yep, I was injured, I fell, no problem. For cumulative trauma injuries, however, the applicant does need medical evidence. Lay testimony alone, I typed for 10 years, therefore my wrist hurts, is not enough to prove injury for a cumulative trauma case. So the applicant must produce medical evidence as evidence of a cumulative trauma injury. And once that happens, the burden shifts to defendant to rebut what applicant says. You see at the bottom, I talk about presumptions. I'll get to that in just a moment. But when you think about the burden of proof, when you think about what we have to do, think about a house of cards. Now, if I was sitting before you, I would have handed out some cards to some of the people up front and asked you to build a house of cards, because the person building the house of cards is the person with the burden of proof. In other words, the other person in the litigation, all they need is to knock one card out, let that house of cards fall, and the first party has not met their burden of proof. So as we move through the presentation today, think about who's building the house of cards, who has to meet each element of their issue to prevail. If they don't do that, they have not served the ball, they have not built their house of cards, and they will not prevail. Now, earlier I asked you about presumptions. Can somebody in the audience here tell me some of the presumptions that apply in workers' compensation? Anybody? Anybody? Well, first off, let me tell you that presumption is simply a rule of law which requires an assumption of a fact from other sets of facts. And in workers' compensation, we're all familiar with the 90-day presumption of compensability. In other words, if we don't deny a case within 90 days, that case is now presumed compensable and can only be rebutted with evidence that's obtained after the 90 days. But there are other presumptions in workers' compensation, such as the presumption that minor children and spouses earning less than $30,000 are dependents of a deceased employee. And for those of you who work with public employees, you know that public safety officers have a cancer presumption. Now, I like to talk about that because think about the place where you're sitting. Look around you. If that room catches on fire, probably everything in your office or your home, your carpet, your furniture, once it burns, it becomes a carcinogen. So if you're a public safety officer, a fireman rushing into a fire, or a policeman outside trying to protect people from that fire, you are breathing in those carcinogens, and it would be next to impossible to show which ones contributed to or caused a cancer. So they give the public safety officers this presumption that the cancer, if they suffer it during their employment or 10 years thereafter for some safety officers, that cancer is related to their work. With that in mind, I give you the case of Riverview Fire Protection versus WCAB, and just notice down at the bottom that the presumption, what it does, it imposes upon the party against whom it operates the burden of proof as to the non-existence of the presumed fact. Now think about the level of impact that has. You have to prove that something doesn't exist. You have to prove that the cancer was caused by something else. We'll get to that in just a moment when we move forward with the presentation here. One other concept I want to talk about before I get into some of the factual things is waiver. If we fail to raise an issue such as an affirmative defense, such as statute of limitations, we waive that defense. We cannot raise it later in the proceedings. We cannot raise it on appeal. And waiver can result from an express agreement, our saying, you know what, we're not going to pursue that. Or it can be inferred from circumstances, such as our failing to raise that issue in a timely manner. So understand, if we have the burden of proof and we fail to act on that, we waive our rights to that issue, such as an affirmative defense. Now, the Labor Code actually does mention burden of proof in Labor Code section 5705, and it mentions that the party, the burden of proof rests upon the party or lien claimant holding the affirmative of the issue, like I said earlier, the person who wants something. And then it goes on to specifically state that affirmative defenses are the burden of the defendant or the employer. Now it lists a series of these, such as intoxication, independent contractor, the prejudice to the employer by failure of the employee to give notice. That's essentially statute of limitations. So the Labor Code does actually assign burden of proof in some instances. But how does the burden of proof work? Well, I give you a very simple factual outline here, where we're claiming that someone's injury resulted from intoxication. Remember, the burden of proof initially lies with the applicant. And for them to make their prima facie case, the applicant merely has to testify that they fell and maybe provide a medical report or an x-ray showing they have a broken bone and they can't work. By giving those pieces of evidence, the applicant has sustained their burden of proof that they were injured at work and they're entitled to benefits. The burden now shifts to defendant, who now must produce evidence, if it's intoxication, that the applicant ingested an intoxicant, that they behaved intoxicated, and ultimately that the intoxication caused the fall. Now, I give this example because when I was young in the industry, I was told of a story of a case where a construction worker went out and drank his lunch. How did we know this? Well, the construction worker in the cab of his truck had a receipt from that day, had a 12-pack of beer that he had purchased and 7 empty cans. He came back to work, he went back onto the job site, and coworkers testified that he was behaving in an odd manner. He walked up to the 3rd floor, he walked off the edge of the construction site. Sounds like a clear intoxication defense. The board, however, found that the intoxication was not the proximate cause of the injury. The board found the proximate cause of the injury was the construction site's failure to put up OSHA-required safety rails around any place where you could walk off the edge, and therefore they found the injury compensable. So understand, you have to meet each and every element before you can prevail. Since we're on intoxication, let's talk about that more. Do you know, does anybody know what the 3 elements that we must prove to prove intoxication? Well, quite simply, they are that applicant ingested an intoxicant, that they were intoxicated, and that the intoxication was the proximate cause of the injury. Now you say, Jim, that should be pretty easy. But think about it in today's world. California now has legal marijuana. I think there's 28 states that allow the legal use of marijuana. Can anybody tell me what the level of marijuana in your system is to indicate that you're intoxicated? I'm guessing the answer is no, because there is no established limit measurement of marijuana in your system that indicates that you're intoxicated. Likewise, with amphetamines, methamphetamines, cocaine, morphine, there is no defined level of blood, a level that indicates that you are intoxicated. So if somebody has amphetamines, marijuana, cocaine in their system, we can argue that they ingested the intoxicant, so we meet element 1, but we need evidence, witness testimony, behavioral comments to show that the person was actually intoxicated, that they were behaving in an intoxicated manner. Then we need to show that the intoxication was the proximate cause of the injury. So if you look down to the Carrillo case on this page, you'll see that applicant had a 0.06 blood alcohol level, but it was denied because there was no evidence offered that applicant was intoxicated. See, in that case, defendant missed the second element. They failed to produce evidence that applicant was intoxicated. And as we move through these cases that I provided you, I'm not going to talk about each one, but you will see that, like in the Burke case, there was no substantial evidence to show that applicant was intoxicated. In the Eastridge case, you'll see that the intoxication defense barred the death claim because decedent's alcohol level was quite high. Look at that, 0.27. They also demonstrated that the intoxication caused the vehicle accident resulting in the death. They met all 3. But you will see in almost every case that I present you where cocaine, methamphetamine, or a drug in which there is no clear measure in the blood to demonstrate that someone is intoxicated, that we can't reach the second benchmark, the second criteria. Therefore, it's hard to demonstrate that the intoxication was the proximate cause of the injury. Now, I'm telling you this because I'm sure some of you are going to have marijuana claims. Some of you are going to have cocaine claims. Some of you are going to have methamphetamine claims. And you have to ask yourself, okay, we've met the first. We can show that they ingested an intoxicant, but we're going to need witness evidence. We're going to need someone to step up and testify that they were behaving in a peculiar manner if we are to prevail. Now look at this one, the Garcia case. The intoxication defense was denied with a 0.12 blood alcohol because the board opines that a blood test alone was not sufficient to prove intoxication. I'll say that again. A blood test alone was not sufficient to prove intoxication. How high must it be for the board to actually say, yeah, that sounds right? Look at Gonzalez. Applicant had 4 to 8 beers before his vehicle accident. And in that case, defendant offered no blood test at all to prove that he was intoxicated. So if we don't meet each and every element of the defense, we fail to meet our burden and we lose. Moving forward, if you look down to the Smith case, you'll see that 0.25, in that case, the defendant presented expert testimony that a 0.25 blood alcohol impaired someone's ability to drive. So in that case, 0.25 was enough. Remember, 0.12 was not. It's just incredible the way the board looks at this. And also in the Dickens case, a 0.429 blood alcohol level, 400 times the legal limit. No reasonable person could conclude the applicant was not intoxicated. We need to meet each and every level of the defense if we are to prevail. Moving forward, there are a lot of affirmative defenses: no employment, independent contractor, and each one of these defenses has elements that we must present if we are to meet our burden of proof. Now, I'm going to talk about some of these as we move forward, but I want you to take note of this page and say, what are the elements of going and coming? What are the elements to establish jurisdiction? What are the elements to establish an independent contractor? Because if you don't know those elements, you will likely not be able to meet those elements and prevail on your affirmative defense. What does the labor code say about independent contractors? Well, labor code section 2750.5 says that if somebody is doing a job that requires a professional license and they don't have that license, they are not an independent contractor. Now you think, Jim, this should be easy to understand, but I want all of you to think of your yards for a moment. Do you have any trees in your yard? Are there trees outside your building? What if you hire somebody to trim that tree? Does that require a license or not? Well, in the state of California, if that tree is under 15 feet, trimming it does not require a license. But if that tree is over 15 feet tall, trimming it does require a license. Now, the question is, do you measure the tree before or after it's trimmed? If a branch reaches up to 16 feet, does that trimmer require a license, or can my gardener do it? The rules all apply, and if you do not have a license to perform a task that requires a business license, you are considered an employee of the person who hired you, regardless of how you hold yourself out as an independent business or as an independent contractor. But if you move forward in Labor Code section 2750.5, they give you criteria such as the right to control, or is the individual in a business that's customarily an independently established business. They lay out groundwork for a judge to consider. And then we have to offer that evidence to a judge and let a judge decide whether each element has been met. That is our burden of proof. I go on to the next page to provide the rest of Labor Code section 2750.5, but I'm going to move forward to go and talk about what we must prove. We must prove, to prove independent contractor, we must show that the worker has control over their outcome, that they have a license if a license is required, that they hold themselves out as an independent business, that they have invested in this business, not just in the service, but rather in tools, maybe advertising, maybe other things to show that they're an independent business. Maybe that we have a contract, or maybe the skills are outside the employer's normal business. Now, these were all the factors that were decided and discussed in the Borrello case. The S.G. Borrello, coming back from 1989, And all of this information was incorporated into that case, establishing defendant's burden of proof. And if we can meet each of these criteria, we can prevail on our burden of proof. Then came along the Dynamex case, which created three questions that if we answer no to any of these questions, the person is not considered an independent contractor. Now, I put these questions on page 28. Is worker free from control and direction in the performance of work? Is the worker performing work outside the scope of the hiring entity's business? And is the worker performing work customarily engaged in an independently established trade? Now, keep in mind, Dynamex was for a wage issue, not a workers' compensation issue. But Dynamex has been incorporated, it's been by the state legislature into the law. So now the judge has far less discretion, and our burden has shifted to answering these questions all in the negative. If we cannot answer each of these questions in the negative, then applicant is not considered an independent contractor, and applicant is considered an employee of the entity that hired him. Now, as an aside, I'm going to go up to the Robinson case. And the Robinson case involved a person who was a handyman around his employer's work site. He did all kinds of jobs. But one of the jobs that he did was welding to repair equipment. One of the jobs was welding. He was not injured welding, but one of his jobs was welding, and welding requires a license. So the board in Robinson found that Robinson was an employee because he was doing welding. Welding requires a license, but he did not hold one, even though welding was not part of his injury. So remember, the board can use the facts in the way that best fits them. That means that our inquiry to our clients of our employers must extend beyond the actual act which they were doing, and must extend to some of the other acts that they may be doing in the course of whatever job they're doing for us. Moving forward, by show of hands, how many of you have had an attorney or supervisor tell you that you will not prevail on your statute of limitations defense? Let me see, I'm counting. There's quite a few of you. Statute of limitations defense is defendant's burden of proof. If we wish to prevail on a statute of limitations, we must meet every element. Now, I didn't list the elements here because the elements extend through the life of the claim. For example, if an employee was not provided with his workers' compensation rights handout upon hire, then we may not have a statute of limitations defense. If the employer did not maintain the notice requirements that they're supposed to have posted in a conspicuous place, we can lose on our statute of limitations defense. If we did not provide applicant with a claim form and a notice of rights at the time of injury, we may lose on our statute of limitations defense. So many actions during the course of employment and in the course of a claim may undermine our statute of limitations defense. Now look at the very first case here, Alvarado. Labor Code section 124B requires that if notices are printed in both English and Spanish, they are to be provided to the injured worker in both English and Spanish. In this case, the claim was not because the notices were not provided in both English and Spanish. Now I was wondering to myself, if Alvarado's name had been Smith, would the board have found the same way? Because the statutes apply whether or not the individual, the injured worker, speaks Spanish. So this could be applied to almost every case and doubles our paperwork requirement. But understand that if we didn't give the notices as required by law, we cannot meet our burden of proof to prevail on a statute of limitations case. Look at the K-Hall case where the defendant failed to give the employee the claim form. You'd think that's a no-brainer. Somebody reports an injury, you give them the claim form. But I'll take it one step further. How do we prove that they gave a claim form? Did the employer put a note somewhere in the file that the claim form was provided? Can we get that person to testify later that they gave them a claim form? So it's not enough simply to give the claim form. We must also Prove that we gave the claim form. Those are parts of our burden of proof for the statute of limitations. Let's talk about New versus Los Angeles Dodgers. Defendant has to prove that the employer had knowledge of the workers' compensation rights. If we can't prove that, then we cannot prevail on the statute of limitations. Now, I will tell you that if you gave the pamphlet at the beginning of employment and you gave a pamphlet upon reporting of the claim, we have evidence that they should have had knowledge of their rights. They could have read the pamphlet. But if they don't do that, if we don't do that, we cannot prevail on statute of limitations. As we go through here, you're going to see case after case after case where we have to present evidence to meet our burden to prevail on a statute of limitations defense. There's some that I specifically wanted to point out, and the Griffin case is one of them, because applicant filed a hearing loss claim with his retirement association. That was noticed to the county that he had hearing loss, and they should have provided him with a claim form and all the notices required when you have notice of injury. Remember, for us under Labor Code Section 5402, I believe it is, notice is from any source sufficient for us to conduct an investigation. So if we get notice from the retirement association that applicant is claiming industrial hearing loss, that's notice that he has an industrial hearing loss claim. So keep that in mind. As we move through here, you will see other cases where we have to prove that they had notice. If you go down, you will see the Nelson Watkins claim, and there was not knowledge of injury. We had to prove that applicant had knowledge of injury. Now, applicant claims that he had stress, but he had both non-industrial and industrial stress. But the board says, because it's a cumulative trauma, that he cannot have knowledge of his cumulative trauma claim until a doctor tells him that he has work injury. Cumulative trauma claim requires medical evidence. Part of our burden for statute of limitations is to show that a doctor told the applicant, and 1 year from that date is the date with which we can try to prevail on our statute of limitations. Look to the Knox versus Prime Healthcare. I get a kick out of this one because when you get a CT claim in, there's always a date listed on the application. That date is just a reference point because the date of injury for a cumulative trauma claim is the date that the applicant had knowledge and disability. And if we wish to prevail on a statute of limitations defense on a cumulative trauma claim, we must prove that the applicant had both knowledge and disability to establish the date of injury, and that he waited 1 year after that to file his claim. Let me move down to the Masri case. I see this a lot. The parties in that case sent applicant to an AME for his cumulative trauma heart injury. And the doctor ultimately found that he didn't have a cumulative trauma. He had a specific injury to his heart. Defendants never sent notice to him about that specific injury. Never sent him a claim form, never sent him a DWC notice of rights. So in that case, they waived their statute of limitations defense by not providing the required information. Think about this when you get a medical report in that cites an injury that we were previously unaware of. We have to address that injury. That's notice. And if we ever want to prevail on statute of limitations, if we want to properly defend it, because presumably our 90 days begins with notice, we have to send the appropriate documentation to the injured worker. Let's leave statute of limitations. Let's talk about intentionally self-inflicted injury. For that, we must show that the applicant performed an act, did something that hurt himself. Injury resulted from that intentional act. But furthermore, we have to prove that applicant intended injury. Look down to the Watson case. Applicant thought that God would heal him, so he didn't take his medication. The board says that that was not intentional. The applicant did not intend the injury. And think about it. How do we prove applicant's intent? How do we show what was in applicant's mind when they did the act? Look at the Smith case on page 33. Applicant punched a wall. There's absolutely no dispute that applicant intentionally punched the wall, fracturing his hand. But where we couldn't show evidence was that applicant intended to fracture his hand. We can't show that it was intent in hitting the wall to hurt himself. So if your defense is intentionally inflicted, self-inflicted injury, ask yourself, what evidence do we have that applicant intended to do this? Likewise, with the initial physical aggressor defense, we must show that the injury arose out of an altercation, that the injured employee was the initial physical aggressor. We don't need to show that there was initial contact, but we do need to show that there was some threatening or intimidating behavior prior to the contact. In other words, I go up to Logan and I act in a threatening manner and she punches me in the nose. I can't claim injury for the punch in the nose. But if I can't meet each one of these elements, I cannot prevail on the initial physical aggressor defense. And as you walk through some of these cases, you will see most of the cases talk about it doesn't require physical contact. In other words, I don't have to punch you first for you to respond. I just need to behave in a threatening and intimidating manner, making you believe that you are in imminent threat. In which case, if our employee is threatening somebody else and that person hurts our employee, we can prevail. But we need each and every element of the defense if we are to prevail. You'll go through these different cases. The Matthews case is the individual who has initially put an opponent in a reasonable fear of bodily injury. There has to be that reasonable fear. I'm not going to dwell too much on the initial physical aggressor because I don't see a lot of those. But look at the Weinberg case on page 36. Words and simulated threats are insufficient to justify this bar. There must be a genuine threat, danger of harm to bar benefits. So that puts a rather high standard upon us. We have to show that the person actually felt threatened and that the behavior by our employee was genuinely threatening. How many of you have seen a claim while committing a felony? As I'm researching this presentation, I'm reading about this. I've actually never handled a defense while someone was committing a felony, but I found out that the injury must occur from the felony. So like in the Fotino's case, applicant was stealing books, but his back injury didn't occur while he was stealing books from his employer. It occurred while he was moving books for his employer. So it was not found to be, this defense was not found valid. Look to the Ease Entertainment case. This case drives me insane because the director in this case, the first assistant director, he asked for a permit to shoot on a train trestle, and that permit was denied. He ignored that, set up a set on the train trestle, and when the train came by, it killed one person, injured 5 others. But he pled guilty under a Georgia leniency law, which turned out didn't constitute a felony. So in this case, if you're looking for a injury while committing felony conviction, the person must be convicted of a felony. If they plead to a lesser case, this defense is no longer valid. We must meet each element for us to prevail. You'll look down at the Leibensberger case. A guilty plea to felony vehicular manslaughter was sufficient to bar benefits. That's the only case I could find where there was actually a conviction or a bar to benefits. Now keep in mind, not every affirmative defense is listed in the labor code, and some of them may be as simple as what is the injury? Now remember, the labor code defines an injury as an incident which causes disability and the need for medical treatment. So for applicant to prevail on injury, they must demonstrate that there was an incident, they must demonstrate that they had disability, or they must demonstrate that they needed medical treatment. Now keep in mind, this applies to both specific and cumulative trauma injuries. So the applicant has the initial burden, but their burden is only a prima facie case. They don't have to present extensive medical evidence. In fact, all they must do is show a reasonable probability of injury, citing the Rosas case. And although the Bates and the Macias de Jimenez case say that they need medical evidence, not just lay testimony, even for specific injuries, it has been my experience that the board will accept lay testimony for specific injuries. Let's keep going. What about the post-termination defense? Well, for defendants, our initial burden is to show that they were terminated or laid off and that the injury was filed after they were terminated or laid off. Two elements, that they were laid off or terminated and that the injury was filed afterwards. The burden then shifts to the applicant to show one of the exceptions. I've listed them on page 41. And then the burden shifts back to defendant to rebut those exceptions. For example, that they weren't laid off or they weren't terminated. Medical discharge or a voluntary resignation is not sufficient. That the employer had notice of injury prior to the termination or layoff, or that there's medical records that show treatment before the layoff or termination. These are exceptions that the applicant must show. Now, I'm telling you this because frequently we will have a post-termination defense, and myself or one of my colleagues will run out and subpoena every medical record from the past. If part of those medical records show that they had treatment to that body part before the layoff or termination, we help applicant meet their burden. And is that what we want to do? Do we want to help applicant meet their burden? What about psychiatric injuries? Well, contrary to popular belief, in California, psychiatric injuries still exist. The only thing that's changed under the labor code is that applicants cannot get permanent disability for a compensable consequence psychiatric injury. But they can still get temporary disability. They can still get other benefits. So it's initially applicants' burden to show that the actual events of employment predominantly caused the psychological injury. Then the burden shifts to defendant to argue the 6-month rule, the post-termination layoff rule under Labor Code Section 3208.3, or that the the psychiatric claim arose from a lawful, non-discriminatory, good faith personnel action. But applicant must first present evidence that the injury was caused predominantly by the employment. If they fail to present that, we don't have to rebut anything. They should lose. Let's keep going. I put in here a slide on discovery simply to say that it is a responsibility of all parties to solicit updated medical reports. In this particular case, defendant went forward and said, gotcha, you didn't get an updated AME report, therefore we're arguing it's not admissible. The judge said, no, each party has a responsibility to keep the medical reports updated. You can't prevail simply by not following through, not doing anything. What about modified work? How many of you have had temporary disability and the employer goes, I've got modified work, yet we still have to pay temporary disability? Well, the initial burden lies with the applicant to show that the employer did not offer modified work. So ask yourself, how does he show that? Well, if we don't have an offer in writing, all the applicant's going to say is, I didn't get offered modified work. Note in the Bonilla case that they say the applicant's burden can be met through applicant's testimony. Then the burden shifts to the employer to show that the modified work was offered. And you will see in each of these cases, it's defendant's burden to show that not only was it offered, but it was within the applicant's restrictions. So if we cannot prove that the work was offered and it was within applicant's descriptions, we cannot prevail in preventing further temporary disability benefits being paid. I put the cancer presumption in here for public safety officers primarily for the burden that we have in overcoming this presumption. Remember, a presumption, we have to prove the negative of the fact. And if you look to the Poirier case right in the middle, we would have to prove that the cancer could not reasonably be linked to the applicant's known exposure to carcinogens. Now, anybody who knows anything about cancer knows there's not a direct cause and effect. If you smoke a cigarette, that does not mean you're going to have lung cancer. If you go out in the sun, that does not mean you're going to have skin cancer. But you could. So think about the burden placed on defendants to show that something could not be reasonably linked to the known exposures or carcinogens. And then think about the fireman rushing into a room that's full of smoke where everything burning becomes a carcinogen when it catches on fire. I'm also going to talk briefly about the medical legal process, soliciting a QME. Now you say, Jim, that's not an affirmative defense. That's okay, because first I'm going to talk about the unrepresented process. And what I'm going to point out to you is the highlighted words on page 46, must and shall. The claims administrator must provide the employee with the form. The claims administrator shall attach the notice advising the claim has been denied. Shall attach a written objection. Shall, at no time shall a claims administrator attempt to use an agreed medical examiner. When I was preparing this presentation and reading through this, I was unaware of number 6 down there. When you schedule a QME exam on an unrepresented worker, the QME must be served, the information of the QME must be served on the employee and include this language. Please look carefully at the enclosed information. Now I'm telling you this because failure to meet any of these musts or shalls invalidates the pro per panel and allows an applicant to get a panel once they are represented. I will repeat that. Failure to meet any of these musts or shalls invalidates the pro per panel and the pro per report and allows the applicant to secure another QME once they are represented. This is important stuff. This is our burden to show that we met every must and shall. Now look at the represented side. There are very few musts. There's a few mays. There's a couple of maybes. There's even a few the parties have days to strike. But there are very few musts in the litigated side, the represented QME process. The QME must be scheduled within 60 days. All information must be provided to the other party. So be aware that there are more requirements on the unrepresented side, and failure to meet any of them may invalidate your panel and may invalidate your report. Now I give you a lot of cases about the QME process. And like before, I'm not going to talk about every case. I encourage you to download the presentation, read them, and find to see if they match your fact pattern. And if they do, more power to you. You can sometimes rebut a panel, sometimes solicit a new panel. But note down on the Gonzalez case that the forms were sent once again in English only, and therefore that invalidated a panel. If the forms are printed in both English and Spanish, they must be sent in both languages. Applicant has 10 days to strike, defendant has 10 days to strike. If we don't strike, the other party can schedule with any remaining doctor. If they don't object to if they object too early to a objection to a medical report, they cannot request a panel, and that panel is invalid. It is very important to know these QME rules so that you can properly obtain a panel and you could rebut a panel that is not properly obtained. Let's talk about apportionment, because apportionment is defendant's burden. If we offer no evidence of apportionment, we do not get apportionment. And if a doctor offers an opinion that is unsupported, we get no apportionment. So for example, in the very first case, Bridgestone, defendants offered no evidence of apportionment and were denied apportionment to applicants' long-standing diabetes. Another word you will see often in the apportionment discussion is overlap. Defendants have to explain how the old impairment overlaps the new impairment if they are to prevail. For example, on the CARES case, the old impairment was based on DRE, the new impairment was based on range of motion. Those are different standards. We have to show how they overlap. And if we fail to do that, if the doctor's report is insufficient and we do not bolster it, we cannot get our apportionment. You'll see down in the Carreras case that defendant did not make any effort to obtain a medical opinion regarding how the old schedule overlaps the new schedule. It is our burden to show overlap. You'll see that time and time again throughout the case law that I provide you. But look at the Rubio case. They were arguing for apportionment under Labor Code Section 4664, yet they didn't provide the prior award. If you're going to argue that you have apportionment to a prior award, at a minimum, you should provide the prior award. Look to the home case, I guess it is. Defendant failed its dual burden of not only showing that there was a prior award, but showing that the prior award overlapped the present injury. So understand that apportionment is our burden. And if we do not meet that burden, we do not get our apportionment. I go through a few more cases here. Make sure you review them. I encourage you to download all the cases, but I want to talk about the medical process and the lien claims. All of you know that treatment is now divided, or the medical process divided into three basic segments. Treatment, which is to cure or relieve from the effects of an industrial injury. Medical legal, which is to prove or disprove a contested claim. And costs, anything that doesn't fall in the other two buckets. Pretty simple determination. But for a lien claimant to prevail on its lien, they have the burden of proof, and they must meet all elements to show the validity of their lien. And I've listed these elements. They must show the itemized request for payment. They must provide you with copies of reports that are relevant. They must provide you a prescription if the service was under a prescription. And they must provide you with evidence of authorization if authorization was required. That was the Torres case, and I give you more information. But notice in the Torres case that they say, proceeding to trial without any evidence or without evidence that is utterly incapable of meeting its burden of proof is frivolous and constitutes bad faith within the meaning of Section 5813, justifying an award of sanctions. Why do I tell you this? Well, I've just given you a series of affirmative defenses, and if we do not have evidence to meet each element, we may constitute bad faith, and we may be sanctioned for asserting a defense for which we do not have evidence. And I give you a series of cases here talking about photocopy and some interpreters. Some of them show that there must be a contested claim if they are claiming the service is medical legal. But look down to the Camarena case where they say defendant waived its defense by failing to contest the costs within 60 days. And then the Juarez case where $1,000 sanctions were imposed for failing to pay or object within 60 days. We still have a burden. We have to act when we get these bills in, and we have to respond to them within a timely manner. And certainly, look to the Santana case, appeals board opines that failure to pay within 60 days is bad faith unless defendant can show mistake, inadvertent, surprise, or neglect. So it is we still have a burden, even though the lien claimant must meet each element to get paid. If they don't, we need to object or we waive our objections. So what have I told you? What have I been saying? Well, if you want to truly understand the burden of proof, you need to know the musts and shalls in the law. You need to know when we have a affirmative obligation to act, hence a must or a shall, and that we act on that. We need to know our evidence. We need to know who has the burden of proof. Where in the litigation stage are we? Who wants something? Who has the burden of proof? And do they have the evidence to meet it? That's why we need to know our evidence. We need to know each and every element to meet our burden of proof. And do we have evidence to meet each and every element? For the intoxication defense, do we have witnesses to say that the individual was actually intoxicated? And does the evidence support each and every element to meet our burden of proof? Is there any evidence that undermines our case? Is there evidence to undermine applicant's case if we're going against the applicant? Because remember, it is oftentimes much easier to undermine the other party's evidence when they have the burden of proof. So look to undermine their evidence, because if they fail to meet their burden, we win. So you need to know who has the burden, what evidence there is available, how we can either use that evidence to benefit us or to undermine them. And does the physician's opinion meet the burden of proof? If not, what do we need to meet that burden of proof? In the end, we don't want to get caught ignoring that burden of proof. That is when we lose. With that, I will conclude and ask for any questions.
Well, Jim, that was outstanding. I loved a lot of that information that you gave, specifically on unrepresented employees. That is a game changer, I think, in a lot of cases. I don't see any questions. Logan, do you see any questions?
I do not.
So we are going to conclude. If we have any questions that came in and we didn't see them, we will make sure that Jim gets those questions for you. Logan, do you have anything you'd like to end with?
I just wanted to say thank you so much for having us, Diane. And again, for everyone who's listening, our emails, my email and Jim's email is up right now. It's at the end of the PowerPoint. So please do not hesitate to reach out to me. Be happy to hear from you. So thank you so much.
And Jim, how about you?
I want to thank everyone for participating, and I do encourage questions. You can email me with any question you have. That is actually the way I come up with presentations. If enough people ask questions, I put it together in a presentation and bring it back. So I appreciate everyone's participation.
Jim, I just got a question. It says, what happens if the injured worker objects to records or cover letters that was sent to a QME?
We have to resolve that issue before we actually send it to the QME. In other words, we have to ask, what is the objectionable language? Can we take that out and solve it informally, or should we file a declaration of application, a declaration of readiness to proceed to address that? Remembering that if we file that DOR, we may have to pay that applicant's attorney fees if he retains an attorney. So can we take the language out informally, or do we need to risk incurring attorney fees?
Got it. So Kurt, if you have any other questions of Jim, you certainly can email him so you can give him a few more specifics. I want to thank all of you for being here with us, and I wish you all a happy, safe, and healthy holiday season. We'll see you at the next Macro Pro and Friends. Bye-bye, everybody.
Bye.